Just a second. The International Criminal Court is now in session.
Good morning. My name is Salim Amin. I'm together here with my colleagues, Judge Asaala and Judge Doi. We are here to discuss the important case of Mr. Gravos. I would like to ask now the prosecution counsel to come forward your charges and present your case before us. And please tell us how you allocate your time. And please also introduce yourself and your university. You will have 25 minutes to go with your pleadings. And then we grant you 5 minutes for your rebuttal and rebuttal for the Counsel of Defense. Now, may I ask you, the Counsel for Prosecution, to come forward and proceed with your charges.
Good day, Mr. President, Your Honors, esteemed colleagues. My name is Tamar Gobajishvili, and I will be acting on behalf of the prosecutor on this matter. I will take up 10 minutes of our total time, and my co-counsel, Ms. Mariam Kafidze, will address the rest of our submissions in 15 minutes. We reserve 5 minutes for our rebuttal. Our university is Tbilisi State University. Thank you.
Counsel? The Counsel for Prosecution, please proceed.
May I proceed the actual pleading now?
Yes, please.
Okay. May it please the court that the OTP submits the following 3 claims. Firstly, the case is admissible before the court pursuant to Article 17. And secondly, the court has material jurisdiction over the case. And finally, there are reasonable grounds to believe that Mr. Gravos is criminally responsible for the crime of genocide under Article 28 of the Rome Statute. Before moving to the first submission, the OTP would like to clarify the burden of proof primarily lies with the party challenging the admissibility of the case before the court. Therefore, the defense must demonstrate the inadmissibility of the case at hand with evidence of sufficient degree of specificity and probative value. Also, the Appeals Chamber had made their precise pronouncements in Gaddafi case in the context of an admissibility challenge lodged by the state, and ruling is still applicable, and there is no reason why the standard of proof for an individual bringing an admissibility challenge should be different from that of a state. Your Honors, bearing in this mind that OTP will now address the first submission and prove that case against Mr. Gravos is admissible before the court based on 2 grounds.
Counsel, may I ask you a question? Could you tell the court what are the elements for the admissibility for this court? How we should proceed with looking at the admissibility issue of the case?
Yes, of course. The elements of the admissibility is that the Republic of Anatun is neither willing nor able to genuinely carry out the investigations pursuant to Article 17, paragraph 1a, and the second, the sufficient gravity to justify the further action by the court pursuant to Article 70, paragraph 1d.
Thank you. You may proceed.
Okay. Thank you, Your Honor, for your questions. Your Honors, bearing this in mind that the OTP will now address the first submission and prove that case against Mr. Gravos is admissible before the court based on 2 grounds. I have mentioned that first, the Republic of Anatun is neither willing nor able to genuinely carry out the investigation pursuant to Article 71a, and second, the case is at sufficient of gravity. As an initial point, there is no evidence to support the defense claim that allegedly ongoing investigation substantially same case on the Republic of Anatun has taken intangible, concrete, and progressive investigative steps to ascertain whether Mr. Gravos is responsible for crimes committed in Caesarea. Your Honors, as deliberated by this very court in its practice, investigative steps could be interpreted into, for example, interviewing witnesses or suspects, collecting documentary evidence, or carry out forensic analysis. The Republic of Hanatun has implemented none of above mentioned. While the defense might argue that the detainment or imprisonment of the accused is sufficient proof to suggest that initial investigation steps have been taken, in reality, the detainment can be easily explained by the fact that Mr. Graus was forcibly removed from the power. Moreover, the accused has been detained 3 months prior to launching the investigations. Once again, it's proving that this detainment is not motivated with the intent to bring perpetrators to justice. And even if the court reaffirmed allegedly ongoing investigations to be covering the same person and substantially the same conduct, the Republic of Hanatun is unwilling to carry out investigations accordingly. The unwillingness criteria should be assessed in the light of principles of due process. Also, we know that ICC is not a human rights court, but human rights standards may still be of relevance and utility in assessing whether the proceedings are carried out genuinely.
Counsel, as I have gone through the facts of the case, I have found out that the case within the Republic of Hanatun, the military court is looking at or investigating the issues from November. And the actions that you are bringing, or the charges you are bringing, they are not including the acts from November. But you are arguing here based on the admissibility issues, and you bring the concept of unwilling. I can differentiate here that maybe this is not the case of unwilling or inability of the court, but it's inaction of the court. Would you argue that's not about unwilling of the Republic of Hanatun, but this is more of a case of inaction, that the crimes are not included and the actions are not included within the investigation of the military court? How would you respond to that? Thank you.
Thank you for raising this point, Your Honors. We think that the unwillingness criteria should be assessed in the light of principles of due process. And I will mentioning that this Republic of Hanatun was unwilling, and we are mentioning that human rights standards may still be of relevance and utility in assessing whether the proceedings are carried out genuinely. The rule of complementarity which is spelled out in Article 70 of the Rome Statute says that interpretative provisions in Article 21, paragraph 3, and the theological approach confirms that if the court is not satisfied that the right of accused will be respected in national criminal proceedings, the case will be admissible. Your Honors, indeed, Your Honors, we submit that same case is not investigated. However, even court was found that investigation was not covering the same case. On 1st September 2021, the situation destabilized on the capital of Hanatun due to clashes between Mr. Graus and his Deputy General Hitch. On the 13th September 2021, a military coup led by General Hitch toppled the government, and he declared himself the Commander-in-Chief and central government. After that, Mr. Graus was placed under house arrest and later held in prison for 3 months before the investigation would start. Bearing this in mind in political context, it's evident that Mr. Graus' fair trial rights cannot be ensured by military tribunal. Furthermore, there is no evidence from the case to suggest that court proceedings were conducted independently and impartially. Proceedings which are conducted independently and impartially implies that the court trials should be trustworthy for the objective person. The prosecution, yes.
Counsel, excuse me if I'm interrupting you, but there is an important issue to discuss here. You mentioned the military court cannot be independent. So what are the elements for independence of the court? Why you suggest that this court is not independent? And what is in the case that it brings you to the conclusion that this military court is not independent?
Yes. Thank you, Your Honor, for your questions. The prosecution is aware of that the fact the court was formed after the military coup scope does not by default implies a lack of independence and impartiality. However, in a given case, the facts are just the opposite. First and foremost, we have to say that the military court was created following the pressure national and international human rights organizations, once again highlighting the unwillingness on the part of the state. Additionally, not a single person has been tried or convicted over the course of existence of the military court. Your Honors, understanding of the relevant context is crucial in this case because this court was made and created by the pressure of international.
Is it not more about the composition of the court itself than how, in which circumstances the court was established? So a court could be established in different circumstances, but it depends how the court would be composed of the judges. How they are appointed, how they proceed with the case. Is it not the case that the court composition is not independent, rather than framing it within the issue of the situation within the Republic of Hanadan? So if we put it within the framework of the situation, I don't see any problems with that, because the situation could change in any country. As far as the court is independent, composed from independent judges, there shouldn't be any issues. May I ask you why you put your emphasis on the situations rather than the composition of the court?
Thank you, Your Honor, for a question. Following the overthrow of Mr. Grabo's government by the General Hage, impartial and objective proceedings would not be desirable for the new government, who we are former subordinates of Mr. Grabo's, considering their role in the commission of crime of genocide that has taken place in Castilla. And that is why we are saying that, mentioning that this court would not be independent. The Republic of Anatun is also unable to carry out proceedings accordingly, specifically due to substantial collapse and unavailability of its national judicial system. The Republic of Anatun was pressured to create military court outside of established judicial system. And indeed, Your Honor, this military court is constituted of Mr. Grabo's ex-subordinate. And may it please the court, the prosecution will now move to the gravity criteria and say that I've got only 1 minute.
I would like to ask my co-judges if they have any questions. If not, please proceed then. Please proceed.
Okay. To conclude the first part of our permission, the national investigation is not covering the same case, and the Republic of Anatun is neither willing nor able genuinely to carry out the investigation pursuant to Article 70, Paragraph 1A. May it please the court, the prosecution will now move to the gravity criteria before addressing the relevant test for gravity assessment. OTP would like to provide the court with a relevant context explanation highlighting that UN Security Council, acting Chapter 7 under of the UN Charter, refers the situation to ICC. Given the Security Council's role and mandate, it becomes evident that crimes committed against Castilians pose serious threat to international peace and security, once again proving at case at hand of sufficient gravity. However, the OTP will employ 3 tests proving that case at hand of sufficient gravity: first, senior leadership test; second, quantitative assessment; and third, qualitative assessment. Given the determination of whether threshold gravity is satisfied requires the objective, quantitative, and subjective qualitative criteria. And in addition, while assessing the quantitative dimension of the gravity, both direct and indirect victims should be taken into considerations. And the blockade of Castilians, severe in famine, and throughout the social media images which show dead bodies of women, and the SPG officers force the women and girls aged 13-24 to provide sexual services and others. Therefore, the overall number direct and indirect victims together with the damage caused by the crime renders it a case of sufficient gravity. And I have to mention that yet another circumstance is a social alarm, and ICC stated in Lubanga case, social alarm is a component of gravity, test particularly relevant. And while the OTP is aware of the difference in factual circumstances of the case at hand, in Lubanga case, our argument relies solely on the findings regarding the social alarm caused the international community in a similar manner. Your Honors, conclude the prosecution's per submission. The case against Mr. Grabus is admissible pursuant to Article 17, and it meets the gravity threshold. Mr. President, Your Honors, if there is no further questions, I would like to thank you for your attention and give the floor to my co-counsel.
Please proceed.
Thank you. Mr. President, Your Honors, good afternoon. May it please the court. My name is Maria Migakide, and I'm appearing on behalf of the prosecution. My co-counsel, Mrs. Kamargovejishvili, showed the court that there are sensible and reasonable justification for the belief that the crime falling with the jurisdiction of the court has been committed. And there are reasonable grounds to believe, excuse me, to believe that the court chamber should exercise its jurisdiction under Article 17 of the court. Your Honors, during the next 13 minutes, I will prove that the first crimes committed against
Counsel, could you please give me the clause under Article 17 based on which we have to look at the issue of you are presenting?
Yes, Your Honor. Thank you for the question. The first issue is about the under Article 17, and I will proceed on the Article 19 and Article 28, third and second and third issues of the case. May I proceed?
You may proceed.
Thank you. Next 13 minutes, I will prove that the first crime committed against Castilians were genocide, and second, Mr. Gross, as a commander, is criminally liable for the genocide crime. Starting with the first issue, the prosecution will prove the following elements. The first, Castilians constitute a different ethnic group. Second, there were committed crimes against Castilians to destroy them in part. Third, that the Castilians were targeted of the crimes because of their ethnicity as such. And finally, the perpetrators have those specialists to destroy Castilians. Starting with the first point, the prosecution stated that Castilians constitute a different ethnic group. As it is directly mentioned in the case text, paragraph 4, they are different ethnic minority. They have different culture, and because of these differences, they were resettled in a different place. During 3 centuries, they have stable and permanent living in Castilla, and they have tight link to this territory. According to Akayasu case, paragraph 513, an ethnic group is generally defined as a group whose members share same language or culture. Sorry, excuse me, some additional elements of COVID-19, excuse me. According to AKSO judgment case paragraph 513, an ethnic group is generally identified as a group whose members share the same—
Counsel,
yes, Your Honor.
I think this court knows what an ethnic group is, or what a group, what makes a group distinct. But I would like to bring you to the case and ask you, so is there any evidence, or do you have any testimony that this distinct ethnic group was targeted and there was an intent to destroy, in part, as you brought it up, this group? Do you have any testimony that not other groups were targeted, but only this group?
Yes, Your Honor. Thank you for raising this issue. The first of all, it is clear that this group was the ethnic group because we have the cumulative elements, language and culture, and also they are the targeted groups as such, and there is the concrete evidences in the case. The fact that Castilians were targeted of the committed crimes as such of their ethnicity is based on the fact and based on the campaign of Mr. Grouse. The defense might speculate in this case that not only Castilians were the members of FSC, but the other groups. But in the case, there is a direct fact that the security—
Counsel, may I clarify my question? My question was, do we have any witness or any testimony to confirm that this group was targeted and not any other groups? Do we have any witnesses in the case? And could you please refer to us?
Yes, Your Honor. We have the evidence and the testimony of Mr. X, who was released after the fact that it was known for the stratagem and indices that he was not Castilian, that he was not from Hanatun. So it means that the only Castilians were the victims of detainments and killing. And also, in addition, there is the exact paragraph in the campaign. We are clearly written that there that the forces should take any and all necessary measures to destroy Castilian supporters. And it means that only Castilian supporters were the targeted groups, not only others. And one another evidence is that Mr. Graus called canceling language to the Castilian and not the FSC members or the other groups.
Councillor, just a follow-up question. Maybe to help me understand, why do you insist that it's the Castilians that are being targeted and not individuals within the Castilians? Why do you insist it's the Castilians when we know very well that the government was targeting individuals, certain individuals within the Castilians?
Please, can you repeat once again, because I cannot understand the question because of technical problem.
Yeah, my question is, why do you insist that it's the Castilians that were being targeted as an ethnic group and not certain individuals within the Castilians?
Your Honor, thank you for the questions. First of all, I want to mention that that not only some individuals were the targeted groups, but the whole Castilians, and it's stated by the fact that because of the blockade and close the businesses, it was for all Castilians, and there was the blockade, and because of this blockade, there are several phenomena which caused them this problem for the all Castilians. In addition, there was the concrete facts of kicking the pregnant women and severe famine, and because of severe famine, women and children were dying. So it means that it's actually and obvious that these children and unborn children and pregnant women, we are not among in the attackers and in fighters, and attacks against them, we are unlawful. It means that the whole Castilians direct to the Castilians, we are targeted groups. May I proceed? Thank you. Thank you, Your Honors. Your Honors, there is a concrete fact that there were the elements of genocide by killing and genocide by the deliberately inflicting conditions, which is expressed by the kicking pregnant woman, the forced sexual services, and severe famine. Also, Castilians were forced to leave their houses, and if they resisted, they were killed. In addition, kicking to the pregnant woman and in the intended acts to reduce the new generation of Castilian. ICTR trial chamber in Kaishima case paragraph 116 stated that the conditions of life could include the rape and starving of the group of people, which was the fact in our case. Your Honor, with your permission, I will move on the third element of special intent to destroy Castilians. And first of all, I want to mention that direct evidence for genocidal intent is not required by the AKS case, and the case facts and surrounding factors are enough to state that there was a special intent. So I will discuss these concrete facts and evidences. First of all, I want to mention that it can be deduced from the words and deeds of the perpetrator that there was a special intent. The plan to destroy Castilians began in 2015, 15 December, and Mr. Grau's government was based on the nationalist ideas. No Castilians were appointed on the government positions, and it means that majority of Hanatun, we are in a much better condition than the minorities one. And it states the fact that members of other groups, I mean Hanu, we are spared. Also, Castoria has a tropical weather, and it was famous for the government that without the supply of water, they would die, and the government did not take any measures, as it was in the case of Darfur.
Council, I have a question.
Yeah.
You mentioned that none of the Castilians were appointed within the government. This could be also seen as a parallel to the even democratic societies. When a party wins the elections, they choose their own government, they choose their own ministers. So they do not have to necessarily appoint any individuals that they belong to other groups or political, let's say, parties. Why you're claiming that this would lead us to believe that this is the intent that a genocide happens? Is there any other evidence within the facts of the case you would say this is exactly what I am presenting to you as the intent, special intent for genocide, and that should not lead us to the probability of the intent of the genocide, but exactly that that the perpetrator is seeking to destroy in part the targeted group? Could you please clarify on that a bit?
Well, Your Honor, starting with the first point, it has to be mentioned that before this government, Kashmirians were very prosperous territory of the Hanatun, and it was clear that they have their own parliament and they have their representatives to the government. Maybe we are not in majority, but they have the members and the representatives in the government. In addition, there was the concrete words against them, and it's one of the evidence that Mr. Graus had a special intent to destroy these people, because he called the cancer and lying words to these people, which means that these people was this violence and hate speech means that they were targeted groups of genocide. May I proceed?
Counsel, you have 1 minute. You may proceed. Yes.
Because of the because I have the only 1 minute, I will submit all the elements for under Article 28, which means that there are 2 points that Mr. Graus knew was the position that he, which is mentioned in Bemba case, for example, that Mr. Graus had the special intent to destroy these people. But even in the case that he did not have this this special intent, it is not necessary, because it is unnecessary that the superior possess the special intent or specific subjective element required in the base crime. Commanders and superiors are made responsible for the crimes committed by their subordinate as a result of their failure to control their subordinates properly. So in the case of negligence, he was obliged to investigate the case, especially in the fact that there was a Security Council referral. He was a commander-in-chief, he was a sub-president, and he has all the authority about his subordinates. In addition, there is a concrete fact that according to Mr. Jolie and Mr. Bryan, that he was the direct command of these subordinates. Finally, according to the fact, it's clear that the case of Mr. Graus concerning genocide is applicable under Article 17 and 18 and Article 28 of the Rome Statute. Thank you.
Thank you, Counsel. May I ask now the Defense Counsel to proceed and bring up your challenges?
Good afternoon, Mr. President, Your Honors. My name is Bishra Altuntaş, and I will be speaking on behalf of the defense before the court. In the next 25 minutes, we will respond to prosecution submissions. First, I will cover the issue of jurisdiction for 8 minutes. My co-counsel, Ms. Avcı, will cover the issue of admissibility for 7 minutes, and Mr. Hamedvengo will cover the issue of superior responsibility for 10 minutes. And with the permission of this court, we will reserve the maximum of the available time for the rebuttal.
You may proceed.
Mr. President, Your Honors, accusations of the crime of the genocide is not something to be done lightly. This crime is not only the manifestation of absolute evil, but it is also one of the cornerstones of this court's jurisdiction. And subject matter jurisdiction of this court depends all elements of the crime of genocide being demonstrated by the OTP on reasonable grounds. The OTP failed to demonstrate anything about the contextual element of the crime of genocide. Elements of crime, which the court applies in the first place as per for Article 21 of the Rome Statute requires such an element. Therefore, the chamber must decline jurisdiction. And I would like to remind you that the OTP has to prove all of the elements, and the burden of proof lies with them.
Counsel, can you tell us any cases, any similar cases that can prove your point? And they say there are any other cases before any international tribunals that they claim the same, or they can prove your point. Can you name us any cases, any jurisprudence?
This court's pre-trial decision on the arrest warrant of Omar al-Bashir case, paragraph 124 indicates to the manifest pattern of similar conduct.
Please proceed.
Now I will turn to our arguments about the elements that OTP has mentioned. And Your Honors, the primary submission of the defense is that this court lacks subject matter jurisdiction. And we have two arguments in support of this position. First, Castrians are not a protected group within the scope of Article 6. And second, neither NSD and SPG forces nor Mr. Gross, the alleged perpetrators, did not have specific intent. Without a protected group—
Counsel, can I interrupt and ask you, what is a protected group under the Rome Statute? Is there any article that it defines a protected group, which the custodians do not fit to that group?
According to Article 6 of the Rome Statute, the criteria are exhaustive. They are national, racial, ethnic, and religious groups. So in this case, we argue that they are not protected group because they are not distinct.
As I went through the facts of the case, they have their own language, they have their own religion, and they practice these religious rituals. So these are the factors that they differentiate a protected group. Why would you still claim that they are not a protected group? Is there any special element that you focus on that, however, they have these distinct language and culture and religion, where they are still not a protected group?
As it was indicated of this court's decision on the arrest warrant of Omar al-Bashir case, their criteria were also indicate to a traditional link to its stance. So, and pursuant to paragraph 4 of the fact sheet, their origin is unknown, and still pursuant to this paragraph, there is no clarity whether they are named after the region they started to live in. And regarding the clarification number 1, the term Castria not only refer to the people of an ethnic group, but also people who reside in Castria. So these points supports our position.
Please proceed.
And these OTP also invoked several conducts as material elements concerning targeting Castrians and conducts regarding killing and deliberate inflicting conditions on life, such as they invoked anti-terrorism campaign was specific target anti-terrorism campaign. However, this campaign was specific targeted against CNF, who are capable of organizing an F-16 ambush, which resulted with the death of many innocent people. And mentioning Castrian supporters only can be misleading for the court, because the paragraph 11A of the fact sheet states that CNF terrorists and their Castrian supporters. So in this context, mentioning Castrian supporters was solely carrying the purpose of preventing CNF terrorists getting support from the local population of Castria or hiding among them. And regarding the fact that the main operation center of CNF is Castria, pursuant to paragraph 4, it is a necessary measure. And the main purpose was not destroying the Castrians as a group. And blockade was similarly carrying security purposes, and the blockade was all over the province of Castria. And in this case, regarding the clarification number 1, how can we say this blockade was—
Counsel, can I stop you? Because there is, I see a conflict in what you're presenting before us and what we notice in the facts. Because the HANU, the SPG soldiers, correct me if I didn't understand the facts correctly, they were in some points, they went to the houses, they were kicking pregnant women in the stomach and chanting that the Casturians are cancer. So if it wasn't very directed to the Casturians and to other groups, or generally why this chanting would happen, that calling Casturians rat or calling Casturians cancer, I didn't see any other facts which says Hanus are a cancer or any other ethnic groups, but why it's only this one ethnic group that's called cancer and being punished for belonging to that group. Could you please clarify that part?
Your Honors, first of all, the only source of these informations are IHRD reports, and their credibility will be challenged by my co-counsel, Mr. Hamed Vengo. Even if we deem these reports as credible, these acts in question do not amount to a concrete and real threat, as it was indicated in the decision of arrest warrant of Omar al-Bashir case. And regarding the statements such as castrations are cancer, pursuant to paragraph 10, Mr. Garbo stated that the media distort his statement and takes his statements out of the context. And regarding clarification number 1, castrations also refer to the people also living in Castria. And even though Mr. Garbo referred to the castrations as an ethnic people, this statement can only amount to establish a personal motive, not a specific intent, in accordance with the Kupres-Kic case. And this brings me to our second challenge concerning subject matter jurisdiction of the court, namely the lack of specific intent to commit genocide. The OTP seems to have relied only on the specific intent of Mr. Garbus, while also invoking his responsibility as superior under Article 6, under Article 28, I stand correctly, which is lawfully incorrect. According to jurisprudence of appeals chamber decision on Kristich case, it is noted that principal perpetrators, independent from their status and ranking, they must have specific intent to destroy the group or part of it. Therefore, it's not only Mr. Garbus, but also NDS and SPG possess specific intent, for which OTP bears the burden of proof. And this concludes my submission. We hope that this court finds and holds that there is no material jurisdiction over this matter. If I have no further assistance, I yield my floor to my co-counsel, Ms. Avcı. Thank you.
Please proceed and give the floor to your co-counsel.
Mr. President, Your Honors, may it please the court. My name is Seman Ravcı. I will plead on the admissibility of the case under Article 17 of the Rome Statute. Your Honors, before beginning, we would like to highlight that we concede that defense carries the burden of proof in terms of admissibility challenge. However, we contest the standard of proof argued by OTP. All the cases they referred to concerns admissibility challenge made by states under Article 19(2)(b) of the Rome Statute. However, in present case, admissibility challenge is made by the accused under Article 19(2)(a) of the Rome Statute. In accordance with the Bembe Pretrial Chamber decision on admissibility, as well as—
Counsel, who decides on the issue of admissibility before this court? Of if this court has the admissibility on the case or not? Is there any authority you can say should decide on the admissibility of the court?
Your Honor's pretrial chamber decides on the admissibility. May I proceed?
Thank you, counsel. You may proceed.
In accordance with the Bembe Pretrial Chamber decision on admissibility, as well as the commentary on the Rome Statute by Kaya Ambos, for defense challenge to admissibility, the standard of proof is the civil standard, namely balance of probabilities, which in fact is a lower standard of proof than what OTP argued. Article 7, now I'm moving into the substantive part of my pleading. Article 17 addresses an admissibility test, which consists of 2 steps in an unspecified order: complementarity criteria and gravity threshold. Your Honors, we concede the gravity of the case, among other things, as the situation is referred by the United Nations Security Council. However, the case is still inadmissible because the complementarity criteria isn't met. Now I will turn to the complementarity criteria, which is not only crucial for the admissibility of this case, but also crucial for this court's functioning and legitimacy. Admissibility is determined based on the factual situation. Therefore, the time we have submitted to our admissibility challenge must be regarded by this court when determining complementarity. When we have made our admissibility challenge, the investigation regarding the case had already begun in Anatun. Republic of Anatun must have taken concrete investigative steps as indicated in the judgment on appeal of Kenya. We would like to clarify that the investigative steps in this case, such as interviewing witnesses or collecting documentary evidence, are just...
Counsel, can I ask you, the investigation which is started by the military court, it concerns only the acts which were commissioned during November, if I'm correct.
I'm sorry,
yes?
Your Honors, but the investigation on the military court focused on the conduct of Mr. Gravus in conflict regions, including Syria, from the year 2015.
My question is, it is about the same conduct. It's not about how the investigation started. So if you want to prove to us this point and say there is an investigation about Mr. Gravus, they may not necessarily include the crimes that are internationally accepted crimes. They may include the normal course of conduct of a normal crime. Could be a murder, which does not include within the admissibility criteria here. So how you prove that, how you justify that this is the same conduct or this is an international crime which was committed during November?
Your Honors, according to substantially the same conduct test, the military court's investigation doesn't require a precise correspondence of incidents before the court. The legal categorization in terms of the type of the crime doesn't matter here, as also supported by the judgment on appeal of Kenya. Once again, we would like to clarify that the investigative steps...
So, Counsel, let's stop here, because this is a very important question, and it will determine if we accept this case and then decide on our admissibility or not. Because it's only one course of conduct which was committed in November, but the charges which is brought by the prosecutor, it is not that same conduct. So there is a bit difference between the conducts. So how would you say that only the conducts which were committed within November will be covered with this investigative body, which is the military court, and not the conduct which is brought to us by the prosecutor? And in a general term, those conducts could be abstract and not directed to a specific course of conduct which is brought to us by the prosecutor. How we can decide on that and say, okay, there is a specific case in November, and then because this investigation is going about that specific case, we will not include the charges which brought to us by the prosecutor, which are a specific course of conduct and the commission of crime.
Your Honors, as you indicated, the investigation on the military court focused on the conduct of Mr. Gravus in conflict regions as of November 2015, which means it not precisely, but substantially covers the same conduct before the court, before the case at hand in the court. May I proceed?
You may proceed.
Your Honors, Hamilton is willing to investigate. First, the investigation is not intended to shield Mr. Gravus from criminal responsibility. We understand the concerns regarding high-ranking military officers' recommendation of Mr. Gravus' release. However, we would like to remind that, according to clarification number 3, these officers have no connection with the military court. Secondly, there is no unjustified delay in the investigation. This is a complex case, since the new government has taken power from the destabilized situation. Despite that, the military court is established with a particular time limit. Third, ongoing investigation in an autumn is impartial, having regard to the principles of due process recognized by international law. The fact that Mr. Gravus is being investigated by a military court doesn't presuppose that his right to a fair trial is violated. According to United Nations Human Rights Committee's General Comment number 32 on the right to equality before courts and tribunals and to a fair trial, there is no violation of the right to a fair trial where military tribunals have exercised jurisdiction or over individuals.
Counsel, which article it talks about, the General Comment 32?
Your Honors, it is not an article under Rome Statute, but general comments constitute subsequent practice pursuant to Article 31, paragraph 30b of the...
I understand that, Counsel. The question is, this general comment is related to which article and which convention?
Your Honors, I am referring to VCLT, Article 31, Paragraph 3, as it constitutes subsequent practice. This general comment constitutes subsequent practice.
Is it not Article 14 of the ICCPR? The general comment 32, it relates to Article 14, is it correct?
Yes, Your Honors.
You may proceed.
Thank you. And there is no violation of the right to a fair trial where military tribunals have exercised jurisdiction over individuals who are military superiors. Therefore, in the present case, there is no violation of the right to a fair trial. Besides, in the judgment on the appeal of Mr. Abdullah Sonisi, appeals chamber clearly stated that the court is not primarily called upon to determine whether certain provisions of human rights law are being violated by the national proceedings. Your Honors, there is also no indication that Honauten is unable to investigate or there is a collapse in its national system. Therefore, it is totally able to investigate the matter. Your Honors, we respectfully request the pre-trial chamber to declare that the case is inadmissible because to hear it will be contrary to the principle of complementarity. Unless I have further assistance, I yield the floor to my co-counsel, Mr. Hamed Venga. Thank you.
Please proceed.
Much obliged, Mr. President, Your Honors. It is a privilege and a responsibility to appear before you today on behalf of the accused person, Mr. Gravers, in a case of singular importance to the court, to the rule of law, as well as to the international community as a whole. My name is Swale Hamed Wengo, and my task today is to conclude the submissions of the defense regarding to the question of superior responsibility as submitted by the Office of the Prosecution. Mr. President and Your Honors, it is our task today, so far as humanly as possible, to stand on the core values of justice. We must never forget that the record on which we judge the accused today is the same record on which history will judge us tomorrow. And therefore, throughout these submissions, we must be guided by the core values of criminal justice, that criminal responsibility should only be attributed to an accused person if there is some form of nexus to the crime. Now, the learned counsel for the Office of Prosecution invoked the provisions of Article 28A. Now, it is vital for the court to note that as per its own jurisprudence, specifically in the pretrial chamber decision in the Bemba case, the court noted that there are 5 criteria or elements that must be established by the Office of Prosecution in order for the court to hold and find that someone is criminally responsible as a superior. And indeed, the court noted that those 5 criteria are cumulative. Where the Office of Prosecution fails to establish even a single one of them, then the court cannot go ahead and hold or find that such a person is criminally responsible as a superior. Now, the counsel for the prosecution in the circumstances of this case only argued first on the specific intent of Mr. Gravers, secondly, that Mr. Gravers had knowledge, and thirdly, that Mr. Gravers had effective control, specifically their words that he had all the authority over the subordinates. Now, in addressing you today, the Office of the Defense will substantiate their argument in 2 limbs. First, it will be our submission that Mr. Gravers did not have effective command and control. And secondly, that Mr. Gravers did not know, nor did he, owing to the circumstances, should have known. Now, in regards to the first limb of argument, it is our respectful submission that Mr. Gravers did not have effective command and control. Now, it is vital for the—
Counsel, can I stop you here? Because you talked about knowledge of the conduct. Is knowledge only sufficient to prove that Mr. Gravers had the effective control? Is there any other element you would say that only knowledge does not suffice the responsibility, but there's also beside that another element? Do you know any of other elements beside knowledge and effective control to lead us to the conclusion that Mr. Gravers is superior responsible and he knew that the course of conduct happens?
Well, indeed, Mr. President, in regards to the jurisprudence of this court, specifically in the Bemba case, the 5 elements: 1, that there is a superior subordinate relationship; secondly, effective command and control, that is pursuant to the provisions of Article 28, or effective authority and control; and then thirdly, that either he knew or owing to the circumstances should have known; and fourthly, whether such a commander goes on to be able to repress the crime, prevent or the fifth one, refer the atrocities to competent authorities. So those are the 5 that the court in the Bemba decision have elaborated on. But as I indicated, for the Office of the Defense, we just need to establish a single one of them has not been met for this court to find that the criminal responsibility has not been established by the Office of Prosecution. Now, as far as effective command and control, the jurisprudence of the ICTY, specifically the Chelebich case, the appeals chamber noted that effective command and control is the material ability of a superior to be able to prevent or suppress the crime. Now, as far as the material ability to prevent, this honorable court in its own jurisprudence, the appeals chamber decision, as well as the trial chamber decision in the Bemba case, has noted that the material ability to prevent of a superior can only exist where such a superior has no geographical distance to where the alleged atrocities are said to have been committed. And indeed, that was a basis upon which the appeals chamber dealt with the matter, considering Mr. Bemba was in the Democratic Republic of Congo and the atrocities happened specifically in Central African Republic. And because of the geographical—
Counsel, can I stop you here? This superior responsibility, it's a very important issue. As we know, this is a Nuremberg court follower. Those are the principles that established the first rules of international criminal law. Do you have anything without the Nuremberg principles that they recall on the superior responsibility? Because the International Criminal Court here, we are following our predecessors. We are looking at the jurisprudence of the previous courts and tribunals. Is there anything within the Nuremberg principles that you could say they constitute also refer to the superior responsibility?
Yes, indeed, Mr. President. As far as the principles in the Nuremberg trials, the principles which are famously known as the Nuremberg principle, Principle 4 also elaborates on this aspect of superior responsibility. And in regards to the question of superior responsibility, as far as that is concerned, is that a superior can be held accountable where such a superior has effective command and control over the subordinates, and therefore it's more of an omission rather than a commission aspect as considered by the jurisprudence in the Nuremberg trials. And to that effect, we submit that in these circumstances, Mr. Gravers did not have any of the criteria established for superior responsibility. And indeed, as I indicated in the circumstances of this case, the only person who had effective control is Ms. Jolie, and she acknowledges actually under exhibit number 1, where she notes that she is personally observing the situation, and if her forces go on to arrest civilians by mistake, then she is able to have those civilians released.
Co-counsel, please allow me to ask my co-judges if they have any questions. If they do not have any questions, I may ask you to proceed.
We may proceed.
Please proceed, Counsel.
Thank you. And therefore, in these circumstances, Ms. Joel is the one who had effective control to prevent the alleged atrocities. What Mr. Gravers had was overall control. And indeed, this is enunciated as per referred to the facts under paragraph 11, where all the heads of the departments are reporting to him, as well as under the last paragraph of exhibit number 1, where she asked Ms. Jolie to be able to inform him of any security concern. A clear indication what Mr. Gravers had was overall control. And as per the jurisprudence of the ICTY, specifically in the Halilovic case, the court noted that a superior having overall control is not sufficient. Such a superior must be able to have effective control over the forces. Now, as far as knowledge is concerned, Mr. Gravers did not know. The learned counsel for the prosecution refers to the reports of international human rights defenders. However, as noted by this court, specifically in the Katanga decision, such kind of reports cannot be reliable by the court if they do not provide who the author is. And indeed, the court in that circumstances was to consider United Nations reports. And the court noted that even though such reports come from such an organization, that means their legitimacy might not be in question, but their reliability will be in question because they do not provide who the author is. And to that effect, we submit that such reports cannot be used as a basis to infer knowledge on Mr. Gravers. Mr. President, I see my time is up. May I just conclude in 30 seconds?
You may conclude in 30 seconds. Just
Thank
one
you.
or two sentences. Yeah.
Thank you, Mr. President. And therefore, in the circumstance of this case, we invite you to reject each and every one of the prosecution submissions for the reasons set out in detail in the submission put to you by myself, as well as by my distinguished colleagues. Those submissions have set out with crystal clarity why none of the prosecution submission passed legal scrutiny. Indeed, the submission of the prosecution were novel, unprecedented, unsupported by the facts, and they were historically absurd, as well as totally unsupported by the text and the negotiating history of this court statute, and therefore they must be rejected. Thank you, Mr. President. That concludes the submission of the defense.
Thank you very much, counsel. I would like to kindly ask now the counsel for prosecution to proceed and present us your rebuttal. You may have 5 minutes.
Thank you, Your Honor. With your permission, Mr. President, Your Honors, together with my co-counsel, I will submit the following points as OTP's rebuttal. Firstly, we would like to respond to the defense's submissions regarding the standard of proof, which was deliberated by this very court in Gaddafi case that the standard of proof for the person challenging the admissibility should not differ different from the one of the state. Thus, the defense should have provided that evidence of sufficient specificity and probative value, which has not been met by the defense as they themselves argued. And secondly, that OTP notes that defense falsely relied on the submissions on the ongoing investigations by the military court concerns to conduct of Mr. Graus. This is not a fact of the case. To the contrary, there is no evidence to suggest that the idea of the investigation covers even remotely the same conduct, namely a genocide, as alleged in front of the court, as it was correctly noted by Your Honor of the military court was established to investigate situation in Hanatun as November 3, 2015. Hence, the creation of the court did not aim to investigate explicitly the conduct of the Mr. Graus. With your permission, my co-counsel will address the rest of OTP's points.
Thank you, co-counsel. Your Honors, I will proceed with the last two submissions. The first one is that about the ethnic group, which was mentioned that there is not the ethnic group like as Castilians. As it was declared in the Akayesu case, the elements of ethnic group is an alternative, but even in the case of Kaishema, there are cumulative elements of ethnic group. It's a language and culture, both we have in this case. And even in the case of Darfur, which was mentioned by the defense, it was mentioned about the territorial link. The Castilians were resettled in a different place because of these cultural differences, and during 3 centuries they have permanent link to this territory, which means that they represent different ethnic groups. And the second issue and submission of the prosecutor is about the specific intent, which will be in accordance with defense arguments in the 3 elements. The first, that he was that Mr. Graus was a person mentioned in Article 28, paragraph A, and he has an effective control on his subordinates. The paragraph 188 of Salovich case emphasizes that doctrine of common responsibility encompasses that not only the person in the de jure position, but in the position of de facto is relevant for the common responsibility. The second, that Mr. Graus knew about the facts and crimes against Castilians because it was completed during 2 years, and it was so massive victims. It was clear for the international organizations and security councils, but despite this fact, and despite the fact that Mr. Graus was talking about these issues, about his speeches, he did not take any measures. And in the case of negligence, there is the important case of Brannon, paragraph 721, which specifies that commanders and superiors are made responsible for crimes committed by their subordinates as a result of their failure to exercise control properly. So in the case that he did not knew, he should have known about these facts because he was a commander, and he did not take any measures to punish or repress these crimes. Thank you, Your Honors. Please pardon for my health problem which caused the process. Thank you.
Thank you very much, counsel. We wish you a very quick recovery. May I ask the Counsel for Defense to come forward and present your rebuttal?
Much obliged, Mr. President, Your Honors. First and foremost, it was the submission of the oath prosecution, specifically on the question of standard of proof. We did concede that the burden of proof lies on us, but we challenge the standard of proof. And they make reference to the jurisprudence in the case of Bemba. But the same Bemba, specifically at paragraph 204, that is the decision specifically of the pretrial chamber on the admissibility and abuse of process challenges, paragraph 204, the court noted that the balance of probability is the standard to be applied when there is a challenge of admissibility. And therefore, the learned counsel for the prosecution maybe have left out certain paragraphs in regards to the determination of standard of proof. As to the question of military courts, it is vital to note that these military courts and their establishment are not in any way in violation of the principles of the right to fair hearing as the Office of Prosecution is trying to allege. First and foremost, this court has noted specifically in the Saif al-Islam Gaddafi admissibility challenge, specifically by the appeals chamber regarding the pretrial chamber admissibility, that in such a situation where the prosecution is invoking the right of fair hearing of an accused person has been violated, then it will be weird for the court to make that determination when he himself, the accused person, is not challenging that his or her rights have been violated. And therefore, if Mr. Gravers is not challenging that his rights were violated, then how can the Office of Prosecution argue that Mr. Gravers' rights were violated? Thirdly, the learned counsel for the prosecution talks about the issue of ethnic group. And indeed, they make reference to the jurisprudence of the ICTR, specifically in Akayesu and Kaishema and Ruzindana. However, it is vital to note that clarification number 1 says that Castrians does not only refer to ethnic minority group, but also the people who live in Castria. And those two cases that they have referred, they provide for the distinct nature of that group. And therefore, how then can we say that Castrians is a distinct nature when we do not know whether in the first they are making reference to an ethnic minority group or the population of Castria? And therefore, the distinct nature is a key part of determination of the ethnic group. Fourthly, the learned counsel refers to the specific element under Article 28. However, Mr. President and Your Honors, the jurisprudence of the ad hoc tribunals has been clear. The Bradanin case in ICTY, as well as the ICTR in Akayesu, Kaishema and Ruzindana, as well as in Musema, has noted that as far as superior responsibility for the crimes of genocide are concerned, the general mental element is the one that is required upon such a superior, and not the specific element as the Office of Prosecution is trying to argue in the circumstance of this case. And therefore, we submit the intent, specific intent of Mr. Gravers is not required as far as superior responsibility is concerned. Lastly, the learned counsel argues that it was clear that the intention of Mr. Gravers was not to take further investigation over this matter. The learned counsel for the prosecution is trying to invoke a threshold that is not applied by this court, which is the hard reason to know under the ICTY jurisprudence. And as noted by the Mukic case, the ICTY stated that as far as a commander is concerned, in the aspect of hard reason to know, is that such a commander had with him information which is of a nature that it would put him on notice of a risk of commission of the crimes by the subordinates, so as to require him to take further investigation to ascertain such truthfulness of that information. And therefore, that is the applicable standard. The Bemba case has indicated that such a standard cannot be applied under the Rome Statute. Under the Rome Statute is only the should have known standard, which they noted that it is the negligent action of the superior that is required as far as the knowledge is concerned. Mr. President, Your Honors, the crime of genocide has evolved from the Genocide Convention, a treaty of singular importance in the history of modern international law, one of the fundamental multilateral treaties of our time. And therefore, to invoke the 1948 Convention, as well as the crime of genocide under the 1998 Rome Statute, is a matter of utmost gravity. It is not something to be done lightly. And therefore, we hope when you retire to make deliberation over this matter, you will be able to ask yourself the critical question whether or not you will allow the Office of Prosecution to invoke the crime of genocide lightly. And the answer to that question lies in the submissions we have made. Thank you. That concludes our submission.
Thank you very much, counsels. The court will go to recess and deliberate on the case, and we will come back with our decision. Dear councils, participants of the court, we had a very fruitful deliberation, and we came to a conclusion and we made our decision. So judges, we would have some comments as well. And we are very much impressed. I'll come back in the end, but I would like to kind of ask my co-judges if they want to have a comment. Judge Evelyne Asaala.
Thank you very much, Mr. President. And I will begin by, just commending the groups, the two teams for the great job. It's very obvious that we all put in a great fight, and we have done our research, we have done the basics really. And therefore, congratulations to both of you. And no matter who wins, we are all winners, right? And nonetheless, there's always room for improvement, and therefore I made some few observations which I would like you to work on going forward. First and foremost, it concerns reference to precedents. Yeah, this is a mistake that I observed both on the prosecution side and also some of the defense prosecutors, also counsels also made this mistake where you refer to a precedent without necessarily referring to the specific paragraph that makes pronouncement on the principle that you're citing to the court. So the first prosecution made this mistake when referring to the social alert in the Lubanga case, basically just blanket reference to the Lubanga case without necessarily making reference to the specific paragraph. And also I think the defense side also made a similar mistake again when referring to jurisprudence. With respect to the second prosecutor, I think your presentation was good, but I'm not sure whether this is related to the kind of illness that you're going through. But I discovered that you had tension within yourself, and you got distorted whenever a question was posed on you, and you have to go off the script and then make a comeback. But nonetheless, that was a good performance. Then with respect to the defense counsel number one, I loved your reference to facts, your calmness, your presentation and all that. But I didn't get the substance of really what I was looking for, because I expected at this level, the defense team should come out strongly, you cite what the prosecution has alleged, and then you just tear it apart with sufficient law and evidence, yeah, to persuade the court to make the decision in your favor. But I didn't quite find it in D1 argument, and D2. D3 tried to come back and just rectify, but in a limited way. And so insofar as my comments are concerned, I think those few were some of the comments that I observed. But overall, I just want to thank the groups and to congratulate you once again. Thank you.
Judge Doi.
Yeah, thank you. So I think so you had already enough or many feedbacks. So even in informal sessions, that's why I will give you only one word. I think you got actually in this session so more questions than you expected before. I think that's why congratulations that you get through or got through such a tough session. I appreciate that really much. Yeah, so far from my side.
Thank you very much, dear judges. I think you mentioned very important points that we discussed in the deliberation room. For me as well, to complement my co-judges, I would say congratulations for the both teams. It's just you made it through the whole competition and came to the semifinals. It's a very good step, and it shows how mature you became in terms of your arguments, not only before, but during this process. We learn a lot. As a student, I did myself the Jessup Moot Court and then in some other courts, moot courts. So this is a very long learning process for everyone. But I wouldn't very much focus on individuals. I would just have some recommendations, and if it meets you, then maybe in the future, if you're doing any moot court, it's important. You guys, everyone started very well, and we are very much impressed. And then we discussed it also in the deliberation. So one point is very important, and if you see, we are intentionally asking you questions to stop you in the question. It's not very much about if you know a specific detail of a law. It's all about how you behave, how you respond to our questions. If we challenge you, how you come back with that. So time management is very important. So don't be scared of your time management. If you have 5 minutes, you can always adjust your time, and then you don't have to put all your arguments. We are not judging you here based on all the arguments you prepared and see if something is left. No, if you have some arguments that they are left outside, what we are focused on, how even if you have 2 points, you discuss 1 point with us and then discuss it properly and the way you present it. And then you can adjust always and say, I'm not able because of the time constraints. I'll focus only on this 1 point, and then you present it based on the time you have. So you don't have to speed up our arguments, because we will lose the track of you, how you are bringing your arguments, and then that even disconnect us to just come with the our to the recommendation. So 1 point, don't be afraid of your time much less. Just adjust yourself. Don't bring all the arguments if you don't have time. Just put it very straightforward. 1 point instead of 2 points is always better if you don't have time constraints. The second recommendation that I have for you is when you're learning the jurisprudence, it's always better to be sure of the jurisprudence. If you're not sure of the jurisprudence, don't come up with the wrong jurisprudence, because the judges always, in the real courtroom, they will know all the law. So if you come and refer to one comment and then you say you don't know which article it relates to, it's not bad that if you don't know the article, but it's how you answer that. If I tell you which article it is, if you don't know that, you can tell the judges that you will look at that and then you will come back to me. I think this is the proper way to answer that question instead of answering it wrong. So as I mentioned, it's not about how much you know about the law, because we know that you are still students and you are still trying to finish your universities, but it's very important how you respond to that. It's also very important the way you respond to the judges. If a judge stops you and asks you a question, it's always better to be diplomatic, to refer them to as a judge, and then you wait for them. They allow you. This is all about the behavior and character of the courtroom. That's also very important for the judges. You both did very, very well. And it's the time, as the organizers told us, to announce the winning team and the best speaker. There was a very close competition between the teams, but from my side, and also we discussed it with our co-judges, that both teams were very, very good. We can understand the part that the prosecutor, a second prosecutor, health-wise was not very well. But we've taken that into consideration. So it's very normal, we are human, that in the courtroom, a prosecution counsel or a defense is sick. But it's also about how you behave, how you respond if you're sick. So the winning team for us, which we decided, is very slightly, so you're both winning teams because the way you did, but we had to decide and pick one team. And the team that's winning is the defense team for us. You did very well. We don't really focus on the mistakes you did, because you both did some mistakes, but you did also very well. But you picked it up very well. You responded very well, and then it somehow compensated the shortcomings that were there. And for concerning the first speaker and the second speaker, so you all did very well. But for us, the third defense counsel became the first speaker for us. The way you presented, especially the rebuttal, the way you responded to the challenges in the rebuttal, and then you didn't bring new arguments. So a rebuttal and rebuttal is not for you to bring new arguments. It's just to emphasize and challenge your opposite counsels. So you did very well. You responded to the rebuttal which came, and then you responded very, very well. Superior responsibility, the burden of proof that was mentioned by the prosecutor, very, very well. So congratulations. And the second speaker for us was the first prosecutor. Prosecution Counsel. You did very well. You started very, very strong, and which personally I was until the middle very much impressed. But the only comment I can give you is just, which I mentioned as my first recommendation, that don't be afraid of your time. Just stay calm and then continue, because it's not about representing all your arguments. I think that was the point that which slightly made us to make another decision. So you did very, very well. So congratulations to you as well. And I wish you all the best for your future studies. And you are the future of international criminal law. So continue this work. And then we have so many atrocities happening around the world. So we need more people to come up and then rebuild themselves as human rights defenders, as defenders of the victims. So with this, I'll conclude my recommendations. This court is adjourned. I wish you all the best.
Thank you, Mr. President, and your honors. We appreciate for your time and for your feedback, and as well as we also appreciate the team number 28 for a good match, and we wish you all the best in your future endeavors. Thank you.
Thank you.
Thank you very much, Your Honors, for the great feedback and advices, and also thank you for the best wishes of the team number 113. Wish you all the best too.
Thank you very much. Congratulations, team 115, and thank you very much.
So I will conclude the session, and I may ask you to leave the courtroom.